Hello and welcome to Legally Speaking with me, Tarun Nangia. Now we commence the part 2 of our discussion on Chief Justice of India, Justice NV Ramana, speaking that shorter judgments, when written, would be in favor of the common litigant. When we discussed in the part 1, we also found out that it could also be benefiting other litigants which are in the commercial arena, not only the common litigant with common matters. In part 1, we continue with the same panel. I have with me Justice Arjun Kumar Sikri, Senior Advocate Amit Desai, Mr. Ryan Karanjawala from Karanjawala and Company, Mahesh Agarwal from Agarwal Law Associates, and Senior Advocate Mohit Mathur, the Chairman of the Delhi High Court Bar Association. We'll continue our discussion from where we left off. I'll go to Senior Advocate Amit Desai. For the fact that 2 points were made in part 1, that arguments can also be shorter, and second, that this initiative of shorter judgments was not a demand from the bar, but an initiative of the bench. Can you, would you want to extend and share your opinion on that?
I don't think I would like to say that this is just an initiative from the bench, because it's an initiative for the system. And it is a reminder today of the realities of the problem that the justice system is facing. And I'm glad that this push is being made. I think, as I told you in the first half, I think the important thing today is no longer the debate. The important thing today is how we are going to achieve a solution to this problem that the system has been facing for the last 5 decades. And I think there's so much material that has been written about how to write a good judgment. I don't think there's any learning on that. It's all about how do you execute. And whilst, I would like to make a few suggestions that I think all of us here have had these years of experience, and the learned judge with judge writing, and he's been, of course, on both sides. We have been on one side. And I think we know how the system works. The question is, which part of the system needs changes? Where do we start bringing about the changes? And I think the changes need to be started right from the bottom. While the third judge mentioned that in the Judicial Academy, where there is interaction with the judges, both of the subordinate judiciary, even the High Court, there is some amount of training which is given for writing of judgments. But I believe today a time has come where we need to take writing of judgments to the law schools. I think there should be, just as there is a course on drafting of pleadings, and we teach youngsters how to draft a pleading, I think it's important to also teach them how to draft a judgment, because they are the very ones who will then be able to understand what really happens in a court of law. The second part, which I say, is when you have these mandatory law clerks for the Supreme Court judges, the High Court judges. This kind of internship would help even the judges who are overburdened with some assistance as to how to put together the data. Because ultimately, when you want to write a good judgment, what are the 6 or 7 steps that you need to take? And these are all well-settled steps, and Justice Sikri will bear this out. You have an introduction. You have your facts. You have the articulation of your issue. You have the evidence to support each of the issues. You have the applicable law. You have the reasoning and findings, and then the conclusion. And these are fairly standard, simple principles in judgment writing. The question is of putting the material together, and in the timeline that the judge has, because there's so many matters that he's doing, to be able to assimilate in every single case this material and put it together in a judgment. So therefore, the second is use the law clerks effectively in assisting in judgment writing. That's the second. The third is, I think, retired judges. There may be subordinate court judges who will assist, because with their years of experience, and let me tell you, 62 really is no age to retire, nor is 65, I'm sorry to say. We're all, that's a separate debate that will go on, but I think we're all sort of in the best of health. We're still very capable of handling ourselves. We understand. We've got 25, 30 years of experience on this subject. But if they are there, then can we not use their assistance and their experience in writing judgments and making sure that they're written? Because you have the principles. So therefore, I think that what needs to be done is really to now figure out that are we ready to now take this? There are, of course, the other issues about in the courtroom, and what is being debated and discussed, which has been said about, is prolixity of arguments. So whether we can now bring in some more restrictions on the amount of time that lawyers will spend in arguing an issue there in Western jurisdictions where you can have limited time for, and proper written notes. So you may actually put together a broad format as to how a written note should be handed over to a court. And work at all these levels in order to ensure that in the next 2 to 3 years or 5 years, we're able to achieve this. Because otherwise, considering the enormous pressure that's there on the justice system today, we are not going to be able to make any headway. We are not going to be able to achieve the fundamental right to speedy justice enshrined in 21. So we are dealing with cases which are 20 years old, 30 years old, 40 years old. So how do we really quickly fast forward? And with the technology that's available, I think now in the last 2 years, all of us have realized that technology can be put to good use. We've all learned a lot about technology. It might be not perfect, but we've learned a lot about technology. We must be able to use that technology. And in the next 5 years, I would say, how do we put a timeline to say, let's clean up the past? I mean, there's been a lot of comment about prolix judgments. I mean, Mohit gave an example in criminal law on Gyanchand. I'll give you another example, which is again coming out from criminal law. The doctrine of vicarious liability is a very simple principle in criminal law. For the last 6 decades, virtually, I don't know, this law has been settled probably in the 60s. I mean, it was settled probably about 100 years ago, but after the Supreme Court, it was reasserted in the judgments of the Supreme Court. But I would say even today, every month, there will be at least 1 or 2 or 3 judgments of the Supreme Court on the same doctrine of vicarious liability. And it all would still run into at least about 10 to 15 pages. Now, why do we need that? So how do we find a way to identify the issues, understand that the issues there is no further development of the law on the subject, resolve it in the context of the facts, and it should be a 2-page order or a 3-page order. You don't need anything more than that. So like this, there are a large number of issues which tend to get repeated before the courts. And we must find a way to also streamline. I believe some years ago, an effort was made in the Supreme Court to try and streamline that. I think that effort should continue. And that is another area where you will then have more time for judges to write good judgments on areas where the law is evolving. Because as we see in this 21st century, there's so much of evolution that's happening in society. And law must recognize that evolution for the next 40 or 50 years. You don't have the time to write all this. Where do we get the time to see what the future is that the judges of the Supreme Court will have to lay down the foundation as we talk about a living constitution? In India, the law evolves with the changing society. But we don't have the time to reflect, to introspect, and see how to bring about those changes in society. So unless we reduce the burden on the judges by helping them in these matters, we are not going to be able to see good law evolving over the next 10 years or 15 years, which is necessary for the country. So I think that it's time to act, and I'm glad that this initiative has been taken by the Chief Justice. And I think it's important that this initiative is now really put into action and no longer just a debate on legally speaking.
Point well taken, but I think we are very positive because our Chief Justice said it. We did not take it up first. Correct. And that's why we are all the more hopeful, because we got a chance to discuss it because it came from him. I'll take your argument to Mr. Ayan Karanjawala. Would you like to extend and put your 2 bits on this issue?
Well, I'll put a little more than 2 bits. So I have a suggestion which is going to be somewhat controversial, but I think the time has come for it. So if we've gone over the debate so far, basically 2-3 things have been said. 1, pleading should be shorter and more crisper. 2, arguments should be more restricted. 3, judgment should be shorter. Now, as far as the pleadings are concerned, that's at a macro level all over India. Just because the Chief Justice has made one statement, that's not going to change. Because when junior counsels are drafting, they're going to put in facts. Clients are going to tell them, no, put this in, put this in, put this in. Nobody's going to take it out and say, no, but I want the judge to be able to write a short judgment. So you're not very likely to be able to change the way pleadings are done. Keeping in mind the kind of counsels we have, the vehemence with which they argue, the egos that they bring to bear. It's not very easy to shut a counsel out. And if at all, that is the function of the judge. So what do we do? How do we handle it? And this is where, as at the break, I had said to Justice Sikri that I'm going to put a sort of a responsibility on the retired judges. And what I suggest is this. Outstanding minds and brilliant judges like Justice Sikri, Justice Rohinton Nariman, Justice Indu Malhotra, Chief Justice Deepak Mishra, and many others, they must come together in an informal committee and every month give a review pointing out, first, in their opinion, which are the well-written judgments of the Supreme Court, so that you draw people's attention to what is good. And then they must summon the courage to point out what, according to them, are the very badly written judgments. You don't have to go and find nitpicking fault with every small thing. But what are the very badly written judgments of the Supreme Court or the High Court and so on? And when you do that, then what you do is you become like a fashion leader. You set a trend. People slowly start. You see, an informal group of retired Supreme Court judges, all of great brilliance, and we certainly have one right here with us. When they set out a trend and they say, look, if I were to have done this judgment and 5 of them say, we would have just eliminated these 20 paragraphs, we would have just gone from here to here to here to here, and this is how we would have done it. You do it once, you do it twice, you do it 5 times. And slowly you will start finding that from the very top, people start listening to you and taking fashion from what you have said. And in one fell swoop, you are able to just cut to the chase and go to the very problem itself. Because ultimately, a lawyer may argue for 500 hours. It's how long the judgment is. It's the judge's discipline. It is the judge's ability to distill what is said, put it down in a disciplined format, which is ultimately what we are looking at. And once you start doing that, it's certainly not a very popular thing to do because no judge wants to be criticized, especially not by his brethren who retired. But that's somewhere along the line, you have to summon the courage. And you don't have to be critical, except where the case is way off back. You can certainly praise the judgments you have liked. Nobody minds that. And nobody minds taking that extra effort to write a judgment, which then gets the informal praise or the formal praise of a group of brilliant, retired judges of the Supreme Court. So that was the one point that I wanted to make, which is slightly out of kilt. The other thing is, there is one exception to this rule of short and concise judgments. Justice Sikri also hearkened to it. He said there are certain important matters which perhaps require it. For example, Justice Bhagwati, even when he was a lawyer, had this habit when he was drafting in the Bombay High Court, putting everything together in one place. So you will notice from Justice Bhagwati's judgments, and there were some of the leading judges like Menaka Gandhi, Motilal Padampat, that he had this habit of then putting every judgment in one place in a melting pot, distilling it, taking out the law, and then that remained the locus classicus, the case that should have been constantly cited. The other thing that the retired judges can do is they can draw up an informal list. It's like the Hasbury's Laws of England. So what you do is you draw up an informal list of cases on particular propositions which are worth citing. So that then when the lawyer goes to court, he doesn't have to cite 15 cases on that point. He just cites that one. And it is only when judges who have seen a full career have sit together in an informal surrounding of congeniality, people who are their friends, people who are their colleagues, and just you take out, see, all the judges, retired judges are also up to date on the law. They keep reading it. Am I not right, Judge? I mean, they're constantly reading it, so they don't require that much effort. They just sit together in an informal setting, maybe even a Zoom once every 2 weeks, and say, okay, look, are there any judgments you guys really liked in this thing? And they say, yes, these are the 5. And you put it down. Bar and Bench carries it. So many other publications carry it. It's carried all over. And slowly it starts creating a situation where people start striving, the sitting judges start striving to deliver the kind of judgment that you suggest that they should. That was my suggestion.
It's a very interesting suggestion. We would like to see how is it taken up, this suggestion. And in fact, your last statement...
There's only one person on this show who can take it up.
No, but your point that they could do a Zoom makes it all the more easier. That, you don't need to meet. You can just do a Zoom every week for 2 hours and discuss it.
The retired judges have a responsibility also to the institution they gave their life to. And to sacrifice a few hours of just to get together and just point the way. Just point the way. You don't have to be overly critical. You can just, you can just praise a few things. You can criticize a few things. And slowly, when you are a sort of a peer pressure, a peer group, a peer pressure group, it works. It evolves.
I'll go to Mr. Mahesh Agarwal. Your comment, will shorter arguments lead to shorter judgments? Or do you think that wouldn't have much an impact?
No, I certainly feel that shorter arguments will definitely lead to shorter judgments, because what happens is, like we said earlier, on a particular point of law, there is a classic judgment which can be cited. What happens is, like Mr. Desai said, 18 judgments have been cited on the same point and all of them are irrelevant. So multiple citing of judgments, case law, facts, multiplies arguments, and at the end of the day, the poor trial judge who has 3 more layers to see up, the judgment will be tested at 3 levels. He's looking at the 3 levels. He's definitely concerned about the 2 litigants before him, but he's also looking at the 3 levels above him as to how he has dealt with the arguments. So if the arguments are detailed and prolix, the judgment is bound to be prolix. That is one part. The second more important point is what Justice Sikri started with, that what are we catering to? We are catering to the 2 litigants who are interested in the judgment. They are like consumers of our judicial system. The whole system has to be consumer friendly. Apart from the length, the shortness or the length of the judgment, what is equally important is the simplicity and the clarity. What happens sometimes is judges borrow technical words, legal terminology. It makes it very, very difficult for the clients themselves to understand. We have all the time cases where after the judgments come, we have long meetings to discuss and understand what has been held in the judgment. We have opinions. We go back to learned retired judges to please give opinion as to what is the meaning of the judgment. Now that can easily be avoided by simple use of terminology, simple use of language. And that is very, very critical for the consumers who come to the judicial system. This is one part. Second, a very important development has taken place, I think yesterday or day before. The Honorable Supreme Court has issued a circular that from Jan 2022, all filings have to be in digital format. Now this digitalization and IT involvement in the legal system will go a long way. Now with the digitalization, it will not be necessary for the judges to give detailed facts or the detailed context. All the entire pleadings, etc. are digitalized. They are available in the system. They can be linked to the judgment. If somebody is interested in seeing the detailed facts or the evidence, you can easily see the digitalized version.
Very good point.
So I think this digitalization and IT initiative by the Supreme Court, which has been taken now, can go a long way in narrowing down the judgments.
Okay.
Very good point, Mike. Very good point you made.
But this is an interesting point, and I'll take this to Senior Advocate Mohit Mathur.
I, in fact, am thankful to Mahesh Bhai for really telling what I was in the part 1 had said, that these lengthy judgments, convoluted judgments are more lawyer friendly, because then people have to come to us for our opinions again. So a revisit and a refresher fee. But that's on the side. But he is absolutely right when he says that simple words and simple language must be used, because the consumer of justice needs to understand what is it that the judge has tried to convey in his case or in the case which he is trying to rely upon or trying to refer upon. Now, there is a very, very important aspect. Again, as I said, that Chief Justice Ramana's observation has to be in the context of Indianizing the legal system. When we say Indianizing the legal system, we have to understand that 50% of India is not in the urban cities. But in strata B or C towns, where people still do not understand the legal jargons, the intricate terminologies which are used, and what we miss out is what we used to be taught by our teachers in English, and referring to Ren and Martin, that there is beauty in brevity. So you have to have beauty in brevity in your words that you use. You have to be economical with your words and then write what you want to say. Something just to take the cue from what Mr. Agarwal just mentioned. In Delhi High Court, we have already have the entire filing as digitized. Fortunately, though the judges have the entire material with them, but unfortunately, they have not chosen the path, but what they have chosen is to pick out the entire text and you put it in the judgment to repeat it as the factual background. The judgments are not connected to the pleadings that are filed in the case. That's a separate entire archives. So technologically, they will have to get onto some system where somebody, because a judgment, once it's a judgment, it's a disposed of case, the record is available to everyone and not just to the parties. So maybe what Mahesh Bhai says has to be seen. But something which I wanted to say as an additional thing, since most of the suggestions have already come, is that there are a lot of concurring judgments which come from Supreme Court. If 5 judges are sitting, we don't need 5 judgments. You can think about what is discussed, and I'm sure they discuss. Since Justice Sikri is here, he can vouch for it and tell us. They must be discussing what is it that they want to decide. So why write 5 judgments? Because I concur with my brother so-and-so, and then again 10 pages. The third one says, I have gone through the judgment of the other 2, but I want to add these things. Arey bhai, why don't you give that point to your brother judge? Let him put it in his judgment. It doesn't take away the credit from you. You are a party to the entire judgment. Ultimately, you are signing it. You don't get an extra credit for it. So why from 50s, when we used to have just 1 volume of SCC, or SCC was not even there, SCR, 1950, we have only reported judgments are the real judgments, the real crux, which actually required to be reported. These orders, which are being for deciding the matters between 2 people, are actually orders. They don't require judgments. A 2-page order saying that this issue has already been decided in X judgment, and therefore, in the facts of this case, this is what is to be decided. What butchering is done on the SLP day, if I may be permitted to use the word, you can butcher the judgment and put it to the requisite need. Butcher may be the wrong word, but then please don't write repetitive judgments. In one case, you will have 5 judgments and all saying the same thing, but in effect, the effect is the same, but repeating the same. Then another aspect which came from your questioning was about arguments being made concise. In part 1 also I mentioned about a system followed by Justice Venkatachalaya, which when we had joined, we saw. Once you asked people, and judges do ask, it's not that it's only in Supreme Court, even in the high courts, judges do ask, please give your written submissions before addressing the arguments. It makes it easier for them also to track down what you are actually trying to make as a point. So please, once you have asked him, the lawyer concerned, howsoever big the name of the lawyer be, why don't the judges, it is the judge presiding on the bench, the onus is on him to not allow the lawyer concerned to stray from the note that he has given or the point that he is making. If the point has 10 points, sub-points to it, and if they are not repetitive, perhaps he can go on. But if they are only re-emphasizing the same thing, then that discipline and decorum has to be enforced by the presiding officer. Another suggestion only is that there are sometimes stray comments coming from the superior judges. And when I say superior judges, it is both the High Court and the Supreme Court judges. When a trial judge, for disposing of a miscellaneous issue, writes a one paragraph, unfortunately, he is badgered for not writing a reasoned order. And these are miscellaneous proceedings, which already stand probably decided, the issues are stand decided by Supreme Court judgments. When he writes a 10-page bail order, again, he is criticized for writing a lengthy order. Now, the difficulty is there is no set pattern, there is no set discipline. And discipline obviously has to come from the top. If Supreme Court does not stray in its own comments, then obviously it can enforce that discipline on the lower judiciary and the high courts as well. There used to be a pattern earlier that there used to be no unnecessary criticism of the judgments of the high courts when it used to go to the Supreme Court, and even when it used to come to the High Court, they would only say, reference that we remit it back. But today, if you see, even while remitting the matter or remanding the matter back, there is a 10-page order which is accompanying it. And sometimes it becomes so confusing that is it the entire issue which has been remitted back? Is it a particular issue which has been remitted back? Are the observations and decisions already effaced when you are remanding it back? Or the merits have not been touched? And as recent as about 5 months back, we had a 100-page bail order. And the Supreme Court only said one line, that don't use this as a precedent for other cases. Those 100 pages had all the law. And it was actually, if you ask me, as Justice Sikri said, you could have written a book. It's a treatise on the entire bail law. But is it required? Fortunately, probably because it was 100 pages, the Supreme Court said that might as well leave it and did not cancel the bail of those people. But otherwise, this much volume is not required. And it only adds to the confusion because there will be words, and as Mahesh Bhai said, the simplicity is lost. When you go on and on and on, the simplicity is lost. The clarity is lost.
Point very well taken and very well explained by Mr. Mathur. May I now request Justice Sikri to conclude today's discussion by taking cognizance of all the comments made by the panel and a suggestion that Mr. Karanjawala made of the informal retired judges group with you, Justice Indu Malhotra, and a few others whom we name. If you like the suggestion.
I think today's discussion, all the speakers have given very, very valuable suggestions. And I'll make some comments on that, as you have said. First, what Mr. Amit Desai talked, two things. One was about the judgment writing in law schools, and it should be at that level. It's not an easy task, but because when a law student is still learning the law and how to write judgment also and going 2 steps ahead of that may be difficult, but at the same time, something which I may tell all who are on the panel and all the viewers who are watching this program, that like moot court competitions, some law schools are organizing judgment writing competitions. I have myself judged those competitions. So therefore, that's a good start. I remember almost 7 years ago, it was sometime in August 2014, in one Pune law school, I think ILS or some law school had started this competition and rather conducted this competition where I had judged that competition. So I know that that is being done, but it should be done at like moot courts. At a much larger scale and by all law schools on a regular basis. That is one thing, but it's a very good suggestion. As far as using law clerks by the judges for writing judgment is concerned, I may tell you here, it all depends on judges. As a judge in the High Court, as a judge in the Supreme Court, I have myself witnessed that some of the judges take the assistance of the law clerks. At least you, from this, what are the facts, what were the arguments by both the sides, and this much of this to prepare ultimate analysis, and whatever is to be decided, I'll do that. That is the main job, but this job you do. And wherever we find that there are some very competent law clerks, and sometimes they are relied upon for this kind of job, and that in a sense gives them the training as well on how to write judgment, because I've seen many of them become judicial officers as well. Now, coming to the suggestions of Mr. Karanjawala, I think what he has said these are, of course, very challenging suggestions which he has given, and very bold suggestions which he has given, but they are worth considering. I assume as a judge of the retired judge and belonging to the system, yes, I am there and I assume that responsibility. Of course, let us see. I'll try to reach out to other judges, and if we can form such a group. Of course, this task is not easy. It may be subject to much criticism, because once many times the sitting judges may say that, look, since you have retired now you are telling us, you are teaching us how to write judgments. We are, after all, judges of the High Court or Supreme Court. How you can tell us? But having said so, forget about judges saying so. In any case, any judgment is always becomes an important judgment, becomes a subject matter of critique. It may be lauded or it may be condemned for whatever are the shortcomings in the judgment. That is the task which the teaching faculty professors also do. That is a task which the legal journalists also do, and on social media also it comes, and in the newspapers, etc. So therefore, and on that, on a lighter side, when it was said that some of the judgments are written in such a manner that which Mahesh said and Mohit also endorsed. I remember one judgment I am not citing, apart from many judgments, where the opinion, if they have come for me for the opinion, in one judgment, I gave 4 opinions to 4 different parties and earned a lot of money because of that one judgment. So, of course, that is on a lighter vein, but yes, that does happen. And sometimes...
Tarun, if I can come in, one of the main reasons why I made bold to suggest was that you have on your panel today not only a judge who, at least in recent times, has been one of the most popular judges of the Supreme Court, but also one of the most academically brilliant. Yes. You know, I mean, we all know about his academic achievements. He's been one of the most brilliant judges. So he's the right person to be the chairman of any such informal club.
No, thank you, Mr. Karanjawala, for your generous remarks. Another thing which you said about the something should be prepared, and instead of then citing so many judgments, the court may rely upon that. This is again not new thing. In America, it happens. This is called restatement of law. It is undertaken by the American Law Institute. Like we have ILI, Indian Law Institute, there is American Law Institute, which does this exercise periodically after every 10 years or 15 years, that restatement of law. And that is a compilation of small book which states gives the restatement means this, that this is the proposition of law and these are the judgments on that. And of course, it is not binding on it can't be cited as a precedent, but it is very commonly in American system, it is cited that, look, this is what it is restated because of the credibility which is attached to American Law Institute. So therefore that can be. And to tell you very interesting thing here, it was way back, who was the Chief Justice at that time? Because I was High Court judge, let me tell you, and in Delhi High Court, and the Chief Justice, I've forgotten the name of Chief Justice, who constituted a committee. on this restatement of law. It was headed by, at that time, Justice Ravindran was the judge in the Supreme Court, and there were 2 or 3 judges of the Supreme Court were taken, and I was taken from Delhi High Court in that committee. And we came out with 3 projects were done initially. We said that these 3 projects should be started, which were ultimate, of course, with the ILI, Indian Law Institute, this thing. So on this was done, but then thereafter, as it happens in our country, this experiment fizzled out. After the retirement of that Chief Justice and retirement of Justice Ravindran, because I continued in this committee, and when I had come to, at that time, Supreme Court also. But this is otherwise a wonderful idea which Mr. Ryan Karanjawala has given, and I think that this restatement committee by Supreme Court should be reintroduced, and the persons who we have to take here, the person, because you can't take judges only. Judges may supervise in the Supreme Court, in the High Court, but we have to take some good professors or good academicians, or maybe from Indian Law Institute also there are such persons who are committed to this cause and then can do so. And this would be, and thereafter that becomes a Bible or our Gita to be cited before the court, and on that basis the proposition of law is stated. It may take care of so much of a problem which is persisting today. So I really commend, of course, Ryan has said so, which was his own idea, but only wanted to tell that this is there already. Yes. But in India, it has not been implemented in the manner in which it should have been. So this is what I would say. And I think I would only like to make one parting comment as far as Mohit has said about the concurring judgments. In the High Court, and that happens in the High Court also, in the Supreme Court also, if there is a 2-judge bench or 3-judge bench or constitution bench, when the matter is heard, of course, thereafter there is a meeting and we confer with each other as to what should be the decision. At that time, the judge who is the presiding judge, maybe Chief Justice or any judge who is presiding judge, he or she would decide that who has to write this judgment also. So normally the practice which had been followed was, but for this latest trend which Mohit pointed out, that the judge who has to write the judgment will circulate that draft of the judgment, and others who have those suggestions, they may give those suggestions and those would be included. But of late, the trend has started that, look, if I have some good ideas, why I give it to him? Why it should not come in my name? And therefore, the trend of concurring judgments has started. And sometimes, and it has gone to the extent, sometimes in the concurring judgment, nothing much additional is stated, but still everybody wants to write. Yeah, this is one tendency here. I would not say much, but only would say that, yes, some self-restraint or some kind of, or maybe Chief Justice may take lead in this. Yes. And may talk to his fellow judges, Chief Justice of the High Court, Chief Justice of Supreme Court, but still in the High Court, it is not happening much. It is more in the Supreme Court, number one, and that too more in the constitutional matters. But which needs to be taken care of. Of course, I can say I was also guilty to some extent that I have written some concurring opinions. But most of the time I thought that once opinion is written, that why not give whatever your suggestions are to your fellow judge who is the author of the judgment and let it be.
Point very well taken. Thank you, sir, for sharing such interesting inputs on, as we conclude our 2-part series on what Justice Ramana, Chief Justice of India, said on writing shorter judgments. I would like to point out that we are lucky that this time we have a very vocal Chief Justice who, in addition to giving speeches where he is invited, makes points which stirs up debate in society. Judiciary is an important stakeholder to the democratic system, and we require our judges to be vocal. And in the form of our present Chief Justice, we found a vocal Chief Justice who speaks his mind. There cannot be a more beautiful thing than this, that time and again he sets forth the point and puts it to the people, because then everybody consumes it. And that's how this issue also came about. Thank you so much, Justice Sikri sir, for joining us. Senior Advocate Amit Desai, Ryan Karanjawala from Karanjawala and Company, Mahesh Agarwal from Agarwal Law Associates, Senior Advocate Mohit Mathur, the much loved President of the Delhi High Court Bar Association, Thank you all. Thank you so much. Thank you, viewers, for tuning in.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.